Hello guys, how are you all? சில பேர் இது வந்து ஹேட் ஸ்பீச் நினச்சிட்டு இருக்காங்க. அது வந்து நம்ம கிளாரிஃபை பண்ணணும். Was Kamal Haasan remark of Kannada about of Tamil qualify under any form of hate speech as it had hurt sentiments of Karnataka state அப்படின்னு கொஷின் கேட்டிருக்கேன். இது GROK சொல்லிடும் கமல் ஹாசன் பண்ணது ஹேட் ஸ்பீச்சா இல்லையான்னு. அதுக்கு தெரிஞ்ச நாலேஜ் வச்சுப்போமே. To determine whether Kamal Haasan remark that Kannada was part of Tamil qualifies as hate speech under Indian law, we need to examine the legal framework for hate speech, the context of the statement and its impact on public sentiment in Karnataka. Below is detailed analysis based on Indian legal standards and the available information. Legal framework for hate speech in India. Hate speech in India is primarily governed by provisions in the Indian Penal Code, Information Technology Act and other law aimed at maintaining public order and preventing incitement against protected groups. Key provision include Section 153A IPC promotes enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. and acts prejudicial and acts prejudicial to the maintenance of harmony. To qualify, the speech must intentionally promote enmity or hatred, target a specific group, linguistic community, example, have a direct tendency to disturb public peace or create disharmony. Section 295A IPC, deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious belief. While this section focuses on religion, it is sometimes interpreted broadly to include sentiments tied to cultural identity. Section 505 IPC, statements concluding to the public mischief, including those creating or promoting enmity, hatred or ill will between classes with intent to incite or likely to incite an offense against public tranquility. Constitutional limits. Article 19(1)A of Constitution guarantees freedom of speech and expression, but Article 19(2) allows reasonable restriction in the interest of public order, decency, morality, or preventing incitement to an offense. Court has clarified that speech must have a clear and proximate link to public disorder to be restricted as hate speech. Judicial interpretation. Supreme Court in Pravasi Balai Sankatan, Union Government of India, emphasized that hate speech must involve incitement to violence or a direct threat to public order to actionable. In Shreya Singhal vs. Union Government 2015, the court struck down Section 66A of the IT Act but clarified that speech causing mere annoyance or offense does not automatically qualify as hate speech unless it incites harm or violence. Speech that hurts sentiment but does not provoke hostility or violence is generally protected under free speech, as seen in cases like S. Rangarajan vs. P. Jaggivan Ram 1989, where the courts upheld the right to express controversial views unless they directly endanger public order. Analysis of Kamal Haasan's remark. Context of the statement. Kamal Haasan made the remark during a promotion event of Thug Life, stating Kannada was part of Tamil, which was perceived by some in Karnataka as derogatory. And dismissive of Kannada's distinct linguistic and cultural identity. Karnataka High Court, during hearing on June 2 to 3 of 2025, noted that the statement hurt the linguistic sentiments given the emotional attachment to the Kannada language in Karnataka. The court referenced historical sensitivities such as C. Rajagopalachari apology for similar claim and suggested Haasan apologies to resolve the issue. Haasan clarified there was no malice in his statement and refused to apologize, arguing it was an expression of opinion without intent to offend. His production house sought legal resources to ensure the film's release, framing the backlash as an infringement on free speech. Impact on public sentiment. The remarks sparkled significant backlash in Karnataka, with pro-Kannada groups like Karnataka Rakshana Vedike threatening arson and protests, leading to the Karnataka Film Chamber of Commerce imposing a de facto ban on Thug Life. The Karnataka High Court acknowledged that the statement hurt the sentiments of Kannadigas, particularly in light of linguistic pride and historical tension over the language identity in state. However, There is no evidence from the sources that the remark directly incited violence or widespread public disorder. The threat came from specific groups, not a general uprising, and Supreme Court on June 17, 2025 criticized these threats as mob-driven intimidation rather than a legitimate response to hate speech. Does the remark qualify as a hate speech? Intent. For a statement to qualify as a hate speech under section 153A or 505 IPC, it must be made with an intent to promote enmity or hatred. Haasan's clarification, there was no malice, suggested that the remark was an opinion, possibly based on linguistic theories, example, the Dravidian language family historical connections, rather than a deliberate attempt to demean Kannada speakers. The Kannada High Court observation that Haasan was neither a historian nor linguistic implies the statement was uninformed but not necessarily malicious. The content, remark asserts a historical or linguistic claim about the origin of Kannada, which may be factually disputed. Kannada and Tamil are distinct Dravidian languages with shared roots but independent development. While offensive to some, it does not explicitly call for hostility, discrimination, or violence against Kannada speakers as a group. Impact. The statement caused offense or and hurt sentiments as acknowledged by the Karnataka High Court. However, under Indian law, mere offense or hurt feelings do not constitute hate speech unless linked to incitement or public disorder. The Supreme Court's ruling on June 17, 2025 emphasized that controversial statements should be countered with debate, not bans or violence, suggesting that the remark falls within protected speech. The court's criticism of the Karnataka government for failing to protect Haasan's rights further indicates the statement was not deemed as a legal basis for restricting the film's release. Public order. While pro-Kannada groups threatened violence, Supreme Court arbitrated the distribution to mobs and vigilantes rather than Haasan's statement itself. The lack of widespread violence on the riots, suggesting that the remark did not have proximate link to public disorder, a key requirement for hate speech under Indian law. Comparison to other cases. In Amish Devgan vs Union Government 2020, Supreme Court held that a TV anchor's derogatory remarks about a religious figure did not constitute hate speech because they lacked intent to incite violence, though they were offensive. Similarly, Haasan's remark, while offensive to some, lacks evidence of incitement. In contrast, cases like Muhammad Iqbal vs State of Uttar Pradesh involved explicit calls to violence against a community, which Haasan's statement does not resemble. In Supreme Court's reference to Bombay High Court decision on Me Nathuram Godse Boltoy in the Taglev case reinforces that the controversial speech, even if it offends, is protected unless it directly threatens public order. Sentiment versus legal threshold. Karnataka High Court focuses on hurt sentiments, reflects the emotional and cultural significance of Kannada in the state, especially amid historical linguistic movements like the GROK agitation. However, Indian courts have consistently ruled that hurt sentiment alone do not justify criminalizing speech as hate speech. The Supreme Court intervention on June 17, 2025 explicitly criticized the Karnataka High Court for suggesting an apology, stating it was none of the High Court's business to demand one. This indicates that the apex court viewed the remark as within bounds of free speech and not hate speech warranting legal action. Conclusion. Kamal Haasan's remark that Kannada was born out of Tamil does not qualify as hate speech under Indian law. While it hurt the sentiments of some in Karnataka, as acknowledged by the Karnataka High Court, it lacks the essential element of hate speech as defined by section 153A, 295A or 505 IPC or judicial proceedings. There is no evidence of malicious intent to promote enmity or hatred against Kannada speakers. The statement, though controversial, does not explicitly incite violence or discrimination. The resulting threats and protests were arbitrated to mob actions by the Supreme Court, not a direct consequence of the remark meeting the threshold for public disorder. The Supreme Court's ruling on June 17, 2025, prioritizing Haasan's right to speech and films released over mob-driven censorship, reinforces that the remark is protected under Article 19(1)(a) of the Constitution, and the court's suggestion that the public debate, not threats, is the appropriate response to such statements further supports this conclusion. While the remark was culturally insensitive to some, it does not cross the legal threshold for hate speech in India. Great, man. Absolutely great. That's it from my end, guys. Hope இது ஒரு நல்ல ஒரு காம்ப்ரஹென்சிவ் வியூ கொடுத்துட்டு நினைக்கிறேன். It's an ongoing issue. நாளைக்கு தான் தெரிய வரும் சுப்ரீம் கோர்ட் என்ன சொல்ல வருதுன்னு. We will follow it through. Hope you enjoyed this video. Like the video if you like the content. Enjoy பார்க்க நல்லா இருந்துச்சுன்னா லைக் பண்ணுங்கள். And if you want to give some suggestions, opinions ஏதாவது இருக்குது, criticism இருக்குது, suggestions இருக்குது, எதாக இருந்தாலும் சரி, make use of a comment section, let me know. If you want to support me, hit that subscribe button. That's the only way you can support any upcoming YouTubers like me. கூட சீக்கிரம் நல்ல வீடியோ சந்திக்கிறேன். Bye bye, see you all, peace out.